everyone, and welcome to the Family Matters Show. I'm Benjamin Bryant of Bryant McKinnon Lawyers, and today I'm joined by my business partner, Heather McKinnon.
Hello, Ben.
Good
welcome
afternoon.
to Christmas.
And Merry Christmas. My ex-partner was violent to my children and me for 13 years and also sexually assaulted me. This has not gone to trial, but I do have an AVO protecting the kids and myself. I have 100% custody of the children, and my ex is only allowed supervised fortnightly visits at Interrelate. He's only attempted to visit the children twice in the last 18 months, and 2 out of the 3 children are too scared of him to attend. There's 2 questions. What happens if I were to suddenly die? Would my ex get custody rights to the children just because he's the father? And is there something that I can put in place to protect my children?
It's a really common area of questions when people have lived through violent situations. So when you go and make a will, probably the most important question for parents who have children under 18 is who's going to be the guardian of those children. So you might appoint your sister and brother-in-law or your parents. If you die, they then make the decision required to look at what's in the best interests of the children. So, for example, in this case, it's quite clear that the father probably doesn't have parental capacity. The children are damaged by him, and it sounds like he has a long history of violence. So if mum did die, people who care about the children, normally aunts, uncles or parents, would make an application to the family court for orders that they have parental responsibility. And I think even at my age, it's amazing how often in my career this actually has transpired, where parents have died through illness or car accidents, and the surviving biological parent hasn't got what it takes to raise kids. So it does happen. It's important that you tell your close family who you would like to raise the children if you are not around, and to make sure that they're aware that they should seek immediate help from a family lawyer if the worst happens. So the court is used to dealing with the situation, and parental capacity isn't just biology. That's the big and important message for us to get through. It's who is best able to raise the children.
And I think the second part of this question that this mother goes on to ask is, can family members essentially make an application for parenting orders or custody of the children, in which you've already answered. And of course, the relevant section is Section 65C of the Family Law Act, and it sets out that parents can apply for parenting orders, children can apply for parenting orders, grandparents can apply for parenting orders, and any other person concerned with the welfare, development or care of the children. Okay, so absolutely family members can. And I think another similar to this is that what people hear about is parental responsibility. Okay, and that there's a presumption that the parents, as opposed to grandparents or anybody else, there's a presumption that there's be an order for equal shared parental responsibility. But of course, I think it's important to note that in circumstances such as this as well, that the court absolutely in the Family Law Act sets out that presumption that parents have equal shared parental responsibility is rebutted if there's a history of family violence or child abuse, or there's other risk factors at play.
Yeah, it's really important. We've still got a long way to go in the culture to get across the message that parents don't have rights. All they have is responsibilities, and if their actions indicate that they're not responsible, then they won't have any ability to see the children.
Merry Christmas. Of course, send any questions that you have to us on Facebook or to our email address familymatters@bryantmckinnonlawyers.com.au. Next show will be on Tuesday, the 8th of January. I think it's the second week in January. So until then, Merry Christmas and Happy New Year.